ourselves in the name of the Father, and of the Son, and of the Holy Spirit. Amen. So, dear Lord, thank you for this opportunity of coming together. We do give you praise today for the gift of life. We ask you, please, to bless us in our efforts as we continue trying to make the justice system more equitable, more fair, bringing light to many, many areas that maybe need your grace to change, and giving your grace to those working in this area, because it's not an easy area to work in. I ask you, please, to bless us, our deliberations today, all the efforts that are going into the making the justice system a better system for all, especially the poor. So may God be with us always and lend his grace to us this day. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
Amen. Thank you, Father Steve.
You're welcome. And I'm going to step away, but hope to be back maybe next week. All right. So thank you.
Thank you.
Thank you.
So we're going to go ahead and begin our program. In the books that all attendees were provided, we provided the introduction and the picture for both people. And of course, their name appears above. So we won't go into heavy introductions so that we have more time for presentation and then Q&A at the end. So without further ado, I'm going to turn it over to Philip and John.
Good morning.
Good morning, folks. What Phil and I have planned to do is I put together a little PowerPoint presentation. Phil and I are going to go through it. It's sort of an overview of the criminal justice system, and with, as Shira talked about too, what action steps can be taken. We have at the end. So I've included some of the laws in the state, but we're not going to go into any legal depth. But I just sort of wanted to put them on the PowerPoint just to let you know that there's resources out there. There are laws out there that deal with some of the various subjects, and this is mainly in regards to bond reviews. But let me go ahead and excuse me, because I have not shared, I was just telling my first screen share was when we were practicing. But let me go ahead and bring that up. Phil, can you see it okay?
I can see it, yes.
Okay. We'll go to the second page. And Phil, go ahead and jump in when you want. The Missouri, as you can see, the Missouri criminal court system, as well as the civil system. Missouri judiciary is based upon 3 levels. We have the Supreme Court, which is at the bottom, and St. Louis's own George Draper is actually the Chief Justice in the state of Missouri. And so we have the Supreme Court, we have a intermediate court that's an appellate court, which means that they render decisions based upon trials. But anyway, it's called the Missouri Court of Appeals, and there's 3 different courts throughout the state. And then the majority of law in the state of Missouri, or in any state, occurs in what we call the circuit courts, except they don't call them in Louisiana, but we won't get into that, Shira, because that will take forever, because Louisiana is built upon the civil law. But the circuit courts in each county. So in order to sort of move along and just sort of flesh that out, let's go to St. Louis County and St. Louis City just briefly and show you what the makeup of the court system here in the city and in the county. I'm actually out in the county, Phil, and I practiced for 34 or 33 years before I became a judge, mainly in the criminal defense field, but I did a lot of civil stuff. But sort of like what Phil does and Shira does, you sort of you specialize in certain areas, but you still dabble in other areas, so to speak. And Phil has practices throughout the state of Missouri, mainly in the eastern half doing criminal defense, but he also does a lot of civil law. So St. Louis City, and I went on their website as well as the county's website and counted this up, so I think I'm right. But there's 24 circuit divisions, 7 associate divisions, 2 commissioner divisions, and we won't go into the breakdown of all those, but just to show you that that is what, 31, 33, that's in the circuit court, separate type of judicial officials. And then the entire city is a municipal court. Where as opposed to St. Louis County, as you can see, there's 21 circuit divisions. They have 14 associate divisions, 6 commissioner divisions, and they have 85 municipal courts. So that in itself could be an hour-long discussion sometime, but there's been a lot since Ferguson. There's been a lot of municipal court reform that I'm sure folks have heard and read about. But St. Louis County is the largest, as I understand it, has the largest volume of cases in the state of Missouri. So I thought, Phil, why don't you take us through this part and I'll jump in. But I thought we'd start out with sort of going through just an overview quickly of the criminal justice system and to sort of, I guess, flesh that out. What happens, and we can get into some issues here about bonds and cash bonds, et cetera, but what happens when a person is arrested for criminal offense? And Phil, I start out, and I apologize if there's any, I try to check to see if there's any spelling mistakes because I've never, it's only the second time I ever put a PowerPoint together. But I started out, Phil, with talking about an individual, let's just say U City. He is arrested for a burglary charge. So when he physically goes into custody, what happens then?
Right. Yeah, you know, it's interesting too, because I am in the middle of a case right now where the family is a good Christian family and very active in their church. And while doing a mission for the homeless, a 14-year-old boy goes somewhere with one of the guys he's serving, basically, working together, getting food and things and other donations. And in the middle of it, he realizes the guy also has some other mental problems, and they are arrested for the actions of the older guy, and the 14-year-old boy was arrested. The family had no idea because they never had any contact with the criminal justice system before. They had no idea what it was all about. So every step they're like, well, asking me for explanations, and I'm saying to myself, everybody should know this, but everybody doesn't know that because the system's different. So someone in Judge Newsom's example here, they're arrested for a burglary on a Monday night in U City. It gets very complicated then because Monday night, obviously the person has to be brought before a judge within 24 hours. But what happens if he's arrested on a Friday night or a Saturday night? Then the 24-hour limitation is excluded because courts here, unlike in a lot of the big places like New York, like you see on Law and Order, courts here are not open on the weekends. So when people tell me my son got arrested on Saturday, I know he's supposed to be in front of a judge in 24 hours. I say to them, that's not necessarily the truth. But after that, if they don't have a warrant for his arrest within 24 hours, they have to release him. If they do, of course, he gets to appear in front of the associate circuit judge within 48 hours. And that's also excluding weekends and holidays. When you get in front of, right now, everything's on Zoom. He appears on Zoom. He's going to be in the jail, and he gets an arraignment, and the judge does an arraignment where he's read the charges and he preliminarily enters a plea of guilty or not guilty.
And Phil, I don't mean to stop you, but there was in the chat, I noticed somebody asked me to do this it would be easier for the public to see if it was done in presentation form. And I apologize. I don't know, honestly, I'm not sure what that means with PowerPoint. I've only used it once before.
Follow my cursor and press this button at the top, right here.
Oh, I can't see your cursor.
So I'm down by the,
Uh-huh.
right here. I'm at the very top.
You're at the top. I've got this.
No, I don't know what I'm looking at there. I
All
see.
right, so you're gonna go right here to this button where it shows a projector slide coming down where it says play, where there's a little play icon. You go in there. At the top in the orange on the left,
Oh,
right there. Up, no, up one more to the left, one more to the left, right there.
oh, I see. Somebody's, there it goes. It's thinking. There we go.
I think you unshared it, John.
Yeah, what happened is it somehow kicked me off the
That's okay.
computer. Wonder why it did that.
So you keep doing that. Phil, keep talking, and John will find the PowerPoint. If I have to text you, that's fine.
Okay, so obviously Judge Newsom is actually in the courthouse right now. He got up and went down to his chambers. And I don't know, there might be some limitations on what he can do from there because it is it has limitations on it being the governmental's.
Oh, here, I got it. Can you see it, Phil?
No,
At the bottom, you'll press share screen. It's green.
No, it's it's something to do, and I apologize. It's something to do when I press that button. My main screen went away. So go ahead, Phil. I'll try to figure this out. And I apologize to you.
so yeah, while we're talking about the arraignment part is where, as I said, you read the charges and you enter a preliminary plea of not guilty. Generally, you don't enter a plea of guilty the first time you go in front of a judge, even if you do believe that you should. You don't have police reports, you don't know anything, so you just enter a plea of guilty and move forward. The next stage is one of controversy for me, where you request a preliminary hearing, which is where they determine whether or not there's probable cause. So the person in our example from University City is going to St. Louis County, and he'll be in front of Judge Newsom probably. And you ask for a preliminary hearing, which is a probable cause hearing. So the problem with that is that there's another little squeeze in their step called bond. At the arraignment, they set a bond, and generally bonds are designed to make sure you come back to court and to protect society. Often the bond that's originally set is something that we defense attorneys want to contest to try to get bond down a little bit lower or to get it lower altogether. And so we have to have a bond hearing. In this example, there's arguably victims involved and they get 5 days notice. So that means a person has to sit in the jail after entering a plea of not guilty for 5 days before he can even try to get his bond reduced. Then at the bond hearing.
Well, what?
Go ahead.
Can you hear me okay?
Yes, I can hear you. We're just seeing the top of your head now.
Boy, whatever I did when I tried to share it, it kicked me out of my whole computer. That's bizarre. But anyway, so when somebody gets arrested, they have to see a judge, or the judge has to sign a warrant within 24 hours. If a judge signs a warrant within 24 hours, that person is also served by the police officer with the warrant. The warrant has to contain release of conditions. So for burglary, let's just say the bond was $20,000 cash only. It may be much less, it may be higher. I'm just picking out a number. Then that person has to be seen after the 24 hour, that person has to be seen within 48 hours, excluding holidays and weekends. Goes up in front of the judge, as Phil was saying. And then when he comes up in front of the judge reads him his charge, tells me he has a right to remain silent. Anything he say may be used against him. Tells him he has a right to an attorney. So for the purpose of this discussion, it's important to know that everyone has a constitutional right to an attorney. So that person, if they're unable to afford an attorney, will get an attorney appointed to them. Uh, and in St. Louis County, and I'm not very familiar with the city system in this regard, but in St. Louis County, they actually will have access in most cases to a public defender at their initial hearing. At the initial hearing, if the bond is $20,000, just for argument's sake, or discussion's sake, I'm sorry, then the attorney or the public defender will say, we would like to discuss modifying or lowering this bond today. But the judge will say this, the rule that's in the materials, but anyway, it's called Rule 3301 and Rule 3305, the rules of release. They have to do with releasing people, what a judge should consider. And since there's a victim involved, that case has to be set for a bond review hearing, but the laws of Missouri allow the victim to be notified, the rights of a victim to be notified if there's a hearing involving a case that they're a victim in. So the case has to be reset, and has to be reset within 7 business days for bond review hearing. So for the purpose of this discussion, it's set the following Tuesday. And then the following Tuesday, the person, if they cannot make bond, will stay in jail. And then they'll have a hearing the next week in front of the judge with the public defender representing them, with the prosecutor representing the state, because I know that Wesley Bell is coming next week, the prosecuting attorney in St. Louis County, and Beverly Hauber, who's the director of the public defender's office in St. Louis County. And so they can add to that. But for the purpose, I think, of this discussion, there's a number of factors the court has to look at to decide whether it should lower the bond or not. And the biggest 2 factors are, will the person come back to court? That's number 1. In other words, do we need what type of cash bond or they call it monetary or non-monetary conditions that need to be set. And then the second part is, does a monetary and a non-monetary bond need to be set, or just does the person should be released on recognizance? I'm sorry, I don't have access to my materials, but a monetary bond needs to be set along with non-monetary conditions. They're all set out in Rule 3301, which the public has access to, which actually had on here on the slide presentation. But anyway, to move the discussion along, the judge will hear arguments from both counsel, and then both people, the prosecutor sometimes brings in victims, and sometimes the defense lawyer brings in family members or treatment folks to say, what are the least restrictive conditions that need to be set to secure the safety of the community, the victim, or any crime witnesses, and to secure the appearance of the defendant at court. That all started in July 2019, and I had an article on the presentation that talked about why that all came about. So if you've heard discussions about cash bonds, that's what this was all in reference to. So anyway, if the judge lowers the bond, the person gets out, and then the court process begins of them going to court and defending themselves against the charges. I think for the purpose of this discussion, once that takes place, we wanted to get into some things that we talked to Shira about what can people who may be on this, or people in the community, how can they participate, I guess, in this how can they participate or find out more information about perhaps bond reviews? So I think in that regard, Phil, I've completely lost my place, but in that regard, I think we wanted to discuss what can people do. It's a Lenten retreat in terms of fulfilling your Christian duty, doing God's will, so to speak. How can people practically make a difference or participate in trying to be a part of a solution in regards to getting people out of jail on bonds, so to speak, and getting them back to court, but really providing some sort of resources for them so they don't get back into a life of crime, so to speak.
Right. So in my experience, first of all, let's start with the general understanding that everyone's innocent until proven guilty. And the fact that someone's charged with things, or a crime, can be pretty devastating to the family. Fathers go away who were support for the family. Children who are very important to the emotional well-being of a family go away. So there's more to the justice system, the criminal justice system, than crime and punishment. So the outreach to families for Christians in this country are pretty much like the outreach for our community in general. There's prayer, first of all, that must be there to support those in this situation. There's the mission of attendance, which means you go to church to show that you're in gathering together in God's name. Then you should be able to go to court to show that you're gathering together in support of a family. Because if that family is in your community, it's your mission to be there in support. I have a case I just mentioned where I have letters from the pastor and prominent members of the church, and by prominent, I just mean people who are actively involved in support of the person that we're trying to get out of the jail. That's something you can do, but also there's going to be a need for some money in many cases, and people in the church can come together to help for people who are indigent and for people who are of lower income, unable to post a $20,000 bond, and that's probably most of us. You can help them with the bond. Then there's also the guarantor situation. But once again, it within the mission of service to the community, there are a lot of people in our community that this service would be very beneficial for. And our presence for these members of the community is very important in these crossroad times, because if we want to get a handle on the ills in our society, especially the crime, we have to show our presence and support. I think Judge Newsom would say that when he was in private practice, he did a lot of work pro bono, which means without charging, just as a part of his Christian service. He probably won't tell you a lot of that himself, though, because he's too modest, but he has done quite a bit of it. And I know that he's inspired us to do it as well.
Well, that's very kind of you. I think, and those were some good points, Phil. I thought for the purpose of a discussion with the group, we could talk about, and certainly Shira or Christine can monitor the chat, but talk about what can you all do to either get involved in the process, as we stated, or to learn more about the process, or to be part of, as I said, solution. Of course, everyone is presumed innocent, but we're talking about the fact that they are charged with a crime, and it puts a tremendous amount of stress on any family. It's so difficult. So I put a list together of some talking points for Phil and I put it together along with Shira, but also so you folks can jump in the chat and ask us if discuss anything, or Shira can jump in, or Christine. So for the purpose of discussion, we talked about the bond review process, which I know is very confusing, especially when you talk about the fact that reform was done. I believe the Supreme Court judge at the time of this, his name was Zell Fisher, back in 2019. This is what he said. Why they came up with a new rule called Rule 3301 that talks about what judges have to consider as to whether to lower a bond or not. It's called, it's called to change the conditions of release, but the practical effect is people are seeking to lower the bond. And Zell Fisher, back in 2019, so he would have been the Chief Justice prior to George Draper, but he said too many who are arrested cannot afford bail even for low-level offenses and remain in jail awaiting the hearing. Though presumed innocent, they lose their jobs, cannot support their families, and are more likely to reoffend. We all share responsibility to protect the public, but we also have responsibility to ensure those accused of a crime are fairly treated according to the law and not their pocketbooks. And I think Shira, when we talked last night, brought up an excellent point, that is sort of the crux of the issue. We, of course, want to protect the public, and people want to live in peace. At the same time, we have to balance it, and I'll let Shira talk about it because she was very articulate last night. But we want to balance that with obviously the rights of people in jail, and really the whole issue regarding cash bonds is certainly ripe for discussion. But anyway, here's some of the points I put together because I don't want to ramble.
Judge Newsome, could
Yes.
could I surface a couple of clarification questions for you and Mr. Dennis before we get into the action steps? Is that all right?
Sure.
Okay, just because I want to make sure that we can clarify a few things that people brought up. Sarah asked to define arraignment.
So what happens in arraignment, and I'm sorry about the computer issues, but what happens in arraignment is, so within 48 hours after John Doe is arrested, excluding weekends and holidays, he's brought in front of an associate circuit judge or a circuit judge. In arraignment, the purpose of arraignment is to read him the charge, to let him know what the state of Missouri, and that's what they call the prosecuting attorney's office in court, the state of Missouri has alleged that a crime that he committed. In this case, the charge would say on or about a certain date, you violated the state statute, and the state statute will be read, and that you went into an inhabitable structure owned by Jane Doe with the purpose of committing the crime, let's say of stealing therein. You would tell him that his bond has been set at $20,000 cash bond, cash only, and again, I'm making this up, but with non-monetary conditions. For instance, he may have to wear an electric home detention bracelet if he is let out, and he cannot leave his house except for work, etc. So there's other non-monetary conditions. I would then tell him he had a right to an attorney. If he could not afford an attorney, one would be appointed to represent him, and I would tell him that he will be given an application from Missouri State Public Defender's Office after the hearing to fill out, at which time that will be sent over to the Public Defender's Office, who will review it to see if he qualifies under their guidelines. And if they do reject him, then the court can hold a hearing appointing the public defender called an indigency hearing. And also tell him he has the right to remain silent. That's the purpose of the arraignment docket. The case then is reset for a bond review docket within 7 business days.
Thank you. And then there was another question that was answered in the chat by Phil, but the question was, do they have to pay the entire bond amount or only 10%? And I know there's a note in the chat, but would either or both of you like to respond to that verbally as well?
Yeah, I typed in, but I'll say it again. Many cases will allow 10% posting. And I think the judges actually have pretty much been pretty good about allowing a 10% posting. But there are some charges that come in and they don't allow 10%. There'll be notes in there that say no 10% allowed. And so I guess I'm not sure because we're doing Zoom lately, so I don't know how many come in or what the number is. I only see my case nowadays when we go on Zoom and handle things. I guess Judge Newsome could probably speak to how that works out too.
Well, 10%, a bond can be set, a cash bond. I don't have it right in front of me, but so a bond regarding the monetary amount can be, if we just use the 20,000 figure, it can be 20,000 cash only, no 10%. It can be 20,000, 10%, which means the person would put $2,000. You can allow property to be posted in lieu of the cash bond, or you could allow surety and or a bondsman to come in and post the bond. So those would be the various ways regarding the cash bond. Various modifications that could be done or could actually be on the original warrant.
Thank you. And then the final question I have noted at this time is from Edward. What time frame is usual for a person arrested as outlined in the offered example earlier to be in jail before going to trial before a judge or jury? What has been the longest time?
Well, it's a great question. And coronavirus has made this even a much more relevant question. I am an associate judge, so my jurisdiction ends on a felony case of burglary after a certain probable cause hearing called a preliminary hearing. Then it goes to the next level, and I'm not involved in the felony jury trials, only misdemeanor jury trials. There are no rules set up to as to how long a case has to, well, there are certain court rules set up, guidelines to how long a case should be pending before it's tried. But the reason I'm hesitating is because coronavirus has changed all that. So we haven't had a jury trial since March of 2020. So we have a huge volume, obviously in St. Louis County, because it's the largest volume in the court, as I said before. So it could be for somebody who's confined awaiting the jury trial. I mean, it could be quite a while depending upon the charge. But in non-COVID times, Phil, how long would a case like yours wait? I mean, it really depends upon, a defendant has a right to request a speedy trial, which would be an entire another discussion, which would expedite everything. The person would have to be confined. But Phil, how long have you seen? It really varies drastically.
Yeah, well, in a lot of felonies, even in non-COVID times, you can't get them over within a year. There's just a lot of steps in between time, and it takes that long. During COVID times, the numbers are even worse, you know, as far as how long. So it's been difficult to explain to my clients what speedy trial is under these circumstances, because no one could ever envision actually what we're going through. And of course, the other thing about speedy trial is when someone is out, when they're out on bond, there's a difference between when you're confined in a jail, speedy trial, and when you're out on bond. In fact, many people, the general approach is that when you're out on bond, the speedy trial is however long it takes. In fact, as of Monday, I was set to try a case that was 26 years old. And I don't know if you looked in the Post or if everyone looked at the Post, that case ultimately got dismissed at the trial date though, because of some other defects. But when you're out, there really isn't a speedy trial requirement.
So,
Yeah.
but basically, it really, a lot of it, to answer the gentleman or lady's question, it really depends upon the lawyers involved. So I'm not talking about folks who are confined, but even folks who are confined. A lot of it depends upon, I mean, a lot of defense lawyers too will continue cases for quite a while because there's a lot of discovery that must be done to prepare for the case. So unfortunately, you could get a case that is tried quickly to a jury, and you could get a case that would drag on for a long time. There's just so many factors that go into it. Go ahead, Christine, I'm sorry.
No, I think there's one more clarification question, and then I think you were going to move on to some opportunities to be involved. So let's plan on going there next. But someone asked for a clarification in the chat. Sometimes a case would go long if the person has nowhere to go, right? Does that question make sense?
Yes, it makes sense on bond reviews. So you may have a gentleman or a woman who's homeless on a bond review, and one of the conditions or one of the things the court will look at is will that person come back to court anyway? Yes, it can delay somebody getting out of jail sometimes if they have nowhere to go for various factors. The court in St. Louis County, I don't know about the city because I'm just not involved in that process, we have with the MacArthur Grant Program that's funded privately by the MacArthur Grant Foundation. And they will go and interview somebody at the initial arraignment before the bond review to see if that person has any substance abuse issues or mental health issues or homeless issues, that they can provide some resources for them. There's an organization called Places for People, and I know the gentleman was in my court for the first time named Eli. It's a tremendous asset to the community, and they provide mental health resources, housing, job resources, and that's one of the talking points I had was Places for People, and how people can get involved, because it does make a big difference when you take a look at somebody's, one of the things you look at sometimes is somebody's home plan,
Mhm.
and really to also to secure the safety of the community and the person itself. But in that regard, yes, it can sometimes, not for a long time, but it can sometimes delay by a week or so somebody getting out of jail sometimes if there is nowhere for them to go, especially if, well, there's several factors. Was that the last question, Christine?
Yes, and I'll just note as you move forward in your presentation, if people have other questions, please feel free to type them in the chat. If it's a question that is better verbally stated, we do have the ability at the end after the presentation to allow people to speak if your question is easier to say out loud. So just feel free to note that or raise your hand at the end if you'd rather ask your question out loud.
And Shira, jump in any time, and Phil too. Here are some of my talking points that I had, and I apologize that the functionality of my PowerPoint won't work, but I put number one, prayer. Number two, I put, in no particular order, court watchers. So we have students and folks from Florissant Valley Community College, where I grew up nearby, who are here almost every day in the morning observing the court. And that's welcome to anybody out there in the public. You can contact the court and get the Zoom number, even though right now we are not doing in-person hearings, which hopefully the next 6 months we will be. But the public is always invited. These courts are always open under the laws of the state of Missouri, including during Zoom hearings. So these folks, they don't participate in terms of other than watching, keeping notes, etc. But I think it's a real benefit. I talked to Shira last night, and I think it makes a real difference for everyone involved to know that the public is there observing. I also put down Places for People. Any organization like Places for People is a huge asset to families, but it's a huge asset to the courts. And it is community involvement. It does not cost the person any money to get involved in those organizations like Places for People. We have sponsored recognizance bonds, sometimes in lieu of cash bonds, in lieu of electric home detention bracelets that are both costly. Sometimes if we have somebody who we can sponsor a person, not financially, but, and then mostly folks, this is family members, but they'll come forward and say that I will get I will show up at jail. I will have the judge will order the person released to that person. And judge, I will let you know if anything, or let the state know or the court know if this person has any difficulties. But basically, sponsored recog. I think anytime folks out there can get involved in providing employment opportunities. One of the biggest things that I wanted to talk about here, because I know we're limited on time and I have a number of other, several other suggestions, is what would happen if John Doe eventually pled guilty, received a conviction for burglary, completed probation, never did any jail time, probation's over with. What happens to John Doe now? He has a felony conviction on his record. So how does he go forward? How does he get a job? How does he support his family? And is there any way he's ever going to be able to get that off his record in these days of the internet and records being so easily available? What can John Doe do? Can he ever get that expunged? So I think one of the things the folks out here can do to help that process or to get more involved in that process is certainly if you're in a position to employ John Doe, even if John Doe at 20 years old had a burglary or let's just say John Doe was found guilty of shooting at a vehicle. And now John Doe is 35 years old. That's 15 years ago. And that assault first charge is still on his record. What can we do in the community to get involved and help people like John Doe? He's obviously been 15 years clear of any charges. John Doe is not going to do that again, but folks sometimes look at John Doe's record and it obviously hurts people. So what about expungements? There are expungements available, laws of the state of Missouri. Shira can talk about that. She was involved in the legislative process with that. So anyway, those are some talking points. Shira, did you want to jump in on the expungements?
I'm going to let you all present, and then I'll try to go at it with questions, kind of thing.
Phil, what did you want to say in regards to this?
Once again, I'm from the Linton perspective, and I guess it shouldn't just be the Linton perspective, but it should be forever. Expungements are a way to clean up a record, basically, to help someone get things off the record. Now, the two things that I know that the judge just talked about, neither one of them at present are expungible, even though it may have been a long time ago when it happened in someone's life.
Well, actually, burglary seconds can be expunged. Burglary first cannot.
That's right. So let's say a person did do a burglary first, though, when he was 19 and now he's 39. And he's basically worked at a menial job, minimum wage, for 20 years, never had another offense, has a family. Right now, he can't get that expunged. And I think the part of the Christian forgiveness would be applied here. I think we should be able to talk to our legislators and say, look, there are people in our community who have done things that we don't expunge, but they've demonstrated a changed character and a changed life. And it's part of our Christian forgiveness to get our legislators to do something about that, to come up with some rules that say, okay, we don't like these kind of charges, but we're going to say that a person that has demonstrated a need and has demonstrated a changed nature and has demonstrated that they're worthy of it, should be able to expunge anything. So it would come from those of you who are gathered together under the name of your church to basically go after and seek out legislators who will help to make that change. And then for the other thing is, expungements cost money. They have to hire a lawyer most of the time because most people are not really good at talking their way through court cases. And then you have to pay filing fees and you have to serve parties in the expungement, and that costs money. So if you want to help out someone as part of your mission, then maybe we should be raising money to help people get expungements and to pay for lawyers to get expungements. I think those things are very important because it does more than help that one individual. It cleans up his record and helps his children, his family. It also cleans up the record and helps our community.
I think it's one of the most practical things folks need to know. I'm speaking from a lay perspective, not as a judge, but because I was in private practice for years. But I think expungements and Shira can jump in because she was involved in this process, but there has certainly been, I know there was something about a new bill. I've not had a chance to review it, but I'm going to, after this, take a look at it because when the expungement bills came out a couple of years ago, they keep, fortunately, they're being added to. But anyway, we could talk about that particular part of it all day, but I think expungements is critical. I think because it's directly related to employment, which is critical. I think in the post-Ferguson reforms in municipal courts. They reformed a lot regarding people not being able to get their driver's license back because of failure to appears. I could talk all day about that because I actually talked at a Ferguson symposium. I was a municipal judge about the need to reform the failure to appears. That has been done. So anyway, that was a practical thing that was done to allow people to get their driver's license back so they could get a job. Expungements is another practical thing that will allow people to get a sort of a new start. As Phil said, the spiritual angle, redemption, and then to probably, hopefully, perhaps get a better job. So there's other areas too. There's a question about what are the current laws in Missouri about asking felonies and job acts. The statute, it's kind of a longer discussion. I'd be happy to discuss with anybody if they want to contact me, but Chapter 610 deals with governmental records, as I recall. I don't know the exact name of the section or the chapter, but 610, I think it's I'm going back on memory. I think it's 105-120 talk about closed records. So that's what it all has to deal with the expungements. So you can take a look in Chapter 610, though it is a bit technical at times. Some of the nuances involved aren't spelled out, but there are statutes allow about closed records and what the employers can see. I always told my clients in private practice, listen, the employer can only see so much, but they can ask you to open up stuff. And I would think, this is when I was a practicing lawyer, that they might have you sign a waiver. So anyway, I haven't practiced in several years. I used to be involved in that a lot, so I'm not quite sure what the current status is. But I think anything that you folks can do to get involved in the process, I think of going to court when they open back up, I think maybe as a community. I used to be involved in a program called SCOPE out of St. Louis University. We had out of the college church. SCOPE was put on by, it was a Lutheran minister. I think he and his wife were Lutheran, or they were involved in it. I can't remember her first name. It was years ago. It was over 30 years ago. But we would sponsor, as a church, we would sponsor somebody coming out of the penitentiary. And we would provide limited monetary, but we provide a lot of non-monetary. We would try to help them get housing, get a job. Tony was a gentleman that we were quite active with. So that's something that can be done. I think it should, if we can get parishes involved, and do things like SCOPE, get a parish committee involved. And we're not talking about financial support, because they were very adamant that you're not, during this program called SCOPE, you're not there to provide financial support, but there's all kinds of things that a church group or committee can do to help people. So that's why I was talking about sponsored recog. Why can't we get the churches involved in the court process? We have hundreds of churches, get groups involved to sponsor a young person who may need some assistance, to be there for the person. Obviously, they are presumed innocent, but to deter them from getting involved in the criminal process again.
So let me push in for a second. I want to play a little bit of the other side, because sometimes our conversations are very, very far in one direction, and I want to push back so that we sort of have a good discussion going with it. One of the things that people say is basically, that's all great. John Doe was doing wonderful, and but he stole from me, and I want his head, because you didn't lose anything. You aren't there to do that. And when people don't look to victims, or sometimes victims have a more powerful voice in some discussions, it comes out as, Judge Newsom, we're going to hold you accountable when the ratings come out. And, Mr. Dennis, we're going to put some things out on the internet about you and how you handle, you defend these kinds of people. How do you deal with that? How does that work for you? It's a job hazard kind of thing. But Judge Newsom, how does it work for you that you have to take some chances with some of these people and you won't get them all right kind of thing? How do you balance that?
Well, it's a great question. I think about it every single day on every single hearing. And I'm very cognizant of what you said. I deny people modifications of bonds and also modify bonds. And I take the victim's rights notice and statements very seriously. as I think all judges do. It's something, as I said, I think about on every single case. I can only say I think it takes experience. It takes a experience as a judge to hear these cases and try to, I think, develop some things that you develop, some factors in Rule 3031 that you look at to see if you can balance the security, you can balance some type of bond modification, especially in regards to non-monetary conditions that will secure the safety of the victim and the safety of the community, and secure, along with listening to whether or not this person, modifying the bond so this person should get out. And I hope I'm not talking around it too much like a politician, but as I'm taking this, I'm thinking of all these other factors that I think about when I hear these bonds. I just think it takes experience, and I think that the more people, the reason I was stressing the more involvement of church groups and stuff is, I think it gives a judge more confidence to lower a bond if, and try to, whether the person can make to get out, if the judge has more assets, so to speak, available that will secure this, that will allow that person to be released, and at the same time alleviate the victim's great concern, as Shira just pointed out. So I don't know if I answered the question.
How do you take that? They say, they may come at you and say something like, you know what, you are just a hired gun. Maybe you're not an ambulance chaser, but you're a hired gun. Anybody that gives you money, you'll defend. So it sounds good when it's coming from you because you've got quite a bit of experience defending people who have done wrong. How do you balance that with the doing the job part with this kind of work, and how you can be effective in the community?
Well, of course, I always give the primary response to we don't defend the act, we defend the Constitution. But I also say that in addition to that, we also have to be reminded about the innocent until proven guilty thing.
Tell me about that. Tell me about the innocent until proven guilty.
Well, you know, it's a well-established concept in our world, especially in democratic world, that one is innocent of a crime, even if they're charged, until it's proven in court that they actually did it.
But what if they did it? What if we all know they did it?
Well, if you all know, I still believe that the Constitution needs to be defended, that the rights of everybody are tested every day in court. And every time we speak to anything, bonds or preliminary issues, we're speaking to the rights of all of us under the Constitution. So for me, every person who's charged is a test on our Constitution that we have to rise to.
So why wouldn't I just, if I know I did it and everybody knows I did it, why wouldn't I just admit it, save the state some money, and get the leniency that way rather than having to go through a trial?
Often that is what happens. And, you know, I have a lot of guys that come to me and say, you know, I just want to take responsibility for what I did. But then there are others who say, you know, I don't like the way they gathered their evidence and they never should have been able to do it. And as I said, we have to test that, you know.
So is it my job to prove that I'm innocent, or is it their job to prove that I'm guilty?
Absolutely. They have to prove your guilt.
So it's not a bad thing then if I ask them to do their job.
Correct. You walk into court, you're considered innocent. You're an innocent man until somebody proves differently.
And they would prove that by going through a trial then.
Yes.
So that's not so trials aren't necessarily a bad thing. That's the system and how it works.
Yes, and everybody that's is sitting next to you in the pews in church, whenever we can do that, should have an obligation to exercise that jury power. They should be down there testing it too, and that's something they can do instead of trying to think of a way to get away from doing jury duty. Everybody should be down there trying to figure out a way to participate in that process.
Besides the pay, I mean, why should anybody want to participate? We've been hearing it 50 million times, and I get that it's our constitutional duty, much like voting, you're supposed to do, you know, jury duty. But what real difference would it make for these listeners or for anybody that is participating, why should we actually participate on a jury? They got enough people.
I certainly think it's amazing. Well, I don't think they have enough people, because the fact that they called my wife 3 times in less than 4 years means that they were running out of options, even though the rule says they're not supposed to do that, get back to you that quick. But I think you say why? Why? Because if you're going to complain about the system but not participate, then you're probably part of the problem. The same thing I tell people who say that they don't vote because, why should they vote? The things that you are not happy with about the system are happening or exist because you don't participate. And I think it's absolutely, although there's a separation of church and state, I think it's absolutely a part of the requirement and the mission of all Catholics and all Christians to be involved in the process of the justice system.
When there's a jury involved, is it helpful to have people with different experiences, or is it better that everybody, because people feel as if, they get cooped up. So, back in the day, we watched Sesame Street, and I'm that kid that's not like all the other kids. I don't want to be on it because everybody, for instance, has a 9-to-5 job, and I work the swing shift or the graveyard shift in a laborer job, and these are all professionals. And I don't know if I belong here or that's a good fit. What would you tell a person who feels they're different or they bring a different experience to a jury pool?
Well, absolutely have to bring people of different experiences together. The whole problem with prejudging or prejudice is that there's not a free exchange of different thoughts and experiences. Therefore, things are judged based on a limited amount of information. A good jury panel has a mixture of all kinds of people.
And also, it's the whole concept that we've all heard before about jury of your peers. So, it dates back centuries ago to the English days about being judged not by the king, but by your fellow citizens. So in order to have a jury of your peers, you have to have people from diverse backgrounds. It's critical to this country. I mean, I think it's the backbone of our entire criminal justice system to have the right to a jury of your peers. And I don't want to get over the top, but I think you're giving back to your country. You're giving back to your city, to your community. I also think that it makes us a stronger country, makes us a stronger community. And it just shows that, as I said, there's so many reasons why jury trials are so important. I think it puts it back in the community. It's then it's not the judge deciding the case or some politician, it's the people of St. Louis County or St. Louis City.
What if the person opts for a bench trial? How do we deal with that? A lot of flack came from the issues that have come in our community lately, where the person, because of what we all just stated and about which we spoke, opted for a bench trial because they had maybe more in common, or they didn't want to go before the jury of their peers. How does that work, and when do they get to decide that? Can the public ask for a rejection? How does all that work for people?
Well, I'm waiting for Judge Newsom because I talk a lot.
Well, a defendant, first of all, the community cannot, not that they can't, there's just no legal process for community to have input in it. A jury trial obviously is where a jury hears the case. A bench trial is where a judge hears the case, and there's no jury involved. And I think Shiver was talking about that case in the city of St. Louis, where a case was tried in front of a judge. The defendant can't waive his constitutional right to a jury trial and try the case in front of a judge. You don't see it many times. Obviously, it is done once in a while. You see it more on a misdemeanor level, that on a felony level, misdemeanor is a lower class offense. A lot of times, you'll see it in misdemeanors because of financial reasons, which is another aspect to talk about regarding the cost of defending oneself. So it's normally a decision made by the defendant and his attorney in regards to, for the reasons that they think they're going to. A lot of times they think that there may be such evidence that a judge may understand better because there's maybe the case is really based on some legal issues and not necessarily on circumstantial type of evidence. But anyway, I'm starting to get off topic and rambling, which I told Shira to promise to stop me from doing that.
So I guess from my perspective as a defense attorney, there are issues that sometimes play better in front of a judge, and especially when in the criminal case you have facts that may inflame a jury to a point where it will not, the jury will not be able to make a proper decision. So it all depends on the kind of case, how you want to go, whether you, and when it's heavily about arguing the law, oftentimes we believe a judge will be able to apply the nuances in the law a little bit differently and better.
So it's not about necessarily getting an advantage, one or the other. It's the defendant's right to do rather than, some secret dark mystery.
Yeah, that's right.
Yes. Yeah, defendant has yes.
Oh, and I want to add too that the same things that we said about these rights and about the Christian support apply also to the civil courts as well. We have people being evicted. We have people who are being sued for credit and debt and other things because that's part of, the difficulties in life. And the Catholic support for these people, I've seen kind of shaky over the years, but I've seen some very good church support for people who have housing cases where their houses are in disrepair. And I remember at some point, several churches had undertaken to help people to fix their houses. But then there's the case that goes with it. So, they need help with that as well. So all of the things we talked about apply also in the civil work as well. But in that last question about bench trial versus jury, sometimes in the civil courts, we have to make those decisions too, because sometimes a case is intensely about the application of the law. And we argue a lot about the application of the law in the case. Sometimes it is about facts that we think a jury can pay attention to a little better, one that we can inject some emotion in, even though that's not a part of the law. It's a part of what, we want a juror panel to be human. And that's why it's good for Christian and Catholics to be on jury panels.
And Shira, just to follow up real quick, Rule 2701, I just looked it up. It's a rule, so it's a law in the state of Missouri. And in Part B of 27.01, if you just Google in quotes or just Google Rule 2701 and Missouri, they'll pop up. The defendant may, with the assent of the court, waive a trial by jury and submit the trial of any criminal case to the court, whose findings shall have the force and effect of a verdict of a jury. In felony cases, such waiver by the defendant shall be made in open court and entered of record. So I just want to let folks know that there has to be some law, rule, statute, etc., behind what happens in a courtroom. And
that's great to know, because people think that, there was this underlying plot rather than the person just has that right constitutionally under the Sixth Amendment, that it flows from such a thing. So if we were to There's been some interplay between diversion programs, and we'll get into some of those because those are actually offered by the prosecutor's office because they're the ones that divert. So that discussion, I would ask you to save your questions till next week because they'll be here to talk about that, and the public defenders will be here to talk about how effective they are. So I see those questions and the different diversion courts. I think it's better for that group of people, but we will touch on them slightly just for you.
Now, I was looking at one of the questions that asked about Shira's background. Besides being from Louisiana, excuse me, and a good Catholic girl, you've been practicing about 15, 20 years now?
Yeah.
And I met Shira in the civil context of a family court case. So she does a lot of family court cases. And then I have spent a lot of time with her sitting around in criminal courts because she does a lot of criminal court cases. And in addition to that, I've seen her in housing court because she represents big housing complexes and others in civil cases there as well. So to give someone, they asked about your background, and I thought they should know that you, like myself, probably have to do everything in order to do our service for our community. We can't just say, I'm only going to do family court. We have to be available for everything.
Yes, and Shira's invited us a couple pre-COVID down to the Rock Church, which was obviously a stunning church inside, and it was a lot of fun. I've also encouraged her to run for office, to seek to become a judge, which she started to do, but to run for office because she has some excellent ideas. As far as diversion courts concerned, in August of 2010, I was a part of a group that helped find that. I didn't do really much, but I was the defense lawyer in a group to set up the DWI diversion court, and I was on it for about 8.5 years. So I don't, next week would be much more appropriate because it's really in Wesley Bell's office that has the most input in diversion courts beside the judge, Stewart, who handles it. But there's the DWI diversion court. The whole purpose of diversion courts is to divert somebody from going to the penitentiary. This not necessarily go to the penitentiary, but that's sort of the theory. Prevent them from being locked up, provide a diversion so that they can get involved in maybe some alcohol or substance abuse, mental health, etc. So that, and then the opportunity a lot of times to keep that particular charge off the record where they don't even have to plead guilty in the end, or the guilty plea can be set aside and dismissed. So the whole purpose is to get them involved in some programs. And DWI, get them involved in substance abuse, alcohol programs, get them involved in doing community service and drugs to get them off drugs, obviously. Mental health, to give them mental health resources. They work a lot with BJC hospitals, and they have mental health social workers. And then they have a veterans court, and they have staffed by veterans and the public has a lot of input in that because, it's unique that how do you understand post-traumatic stress in a combat situation if you were never in combat? So anyway, I just wanted to say that just briefly.
Can I surface a few of the questions that have come up in the chat that I have noted? And please let me know if they are better served for another week, but just trying to track some of the stuff that's been asked. And we had a couple of questions around restorative justice. Someone asked, are there currently any programs that promote restorative justice or alternative sentencing? And then someone asked similarly, have courts in Missouri considered restorative justice practices? Can either of you speak to that?
So restorative justice means to restore someone back to where they were before the system and they interacted. Missouri is not really the best at that yet. We're working on it. And, I had skepticism over the years as to whether Missouri was ever going to get on track with that. But I've seen some good stuff from Governor Parsons. The restorative justice he has done quite a bit of is pardons. And he started to realize that there were nonviolent drug offenders who've been sitting in jail for far too long, and that it didn't do enough just to tell them they could go home. He had to actually pardon them, get rid of the record altogether with. As far as the two types of things, I guess diversion court is a restorative thing, because a person with a drug offense is sent through a drug court, and at the end he may end up with a dismissal of the case from his record. So that's a very restorative thing to do. What I'm very concerned about is, I would say, if it's a big city, St. Louis, Kansas City, St. Louis City or St. Louis County, St. Charles, and Jefferson County, I think we can count on seeing a lot of compassion in these new programs. When you get a little further out, and I know Judge Newsom wouldn't speak to this because he probably can't as a jurist, but when we get a little further out, I think their programs are not very good at all. And I think they attempt to show that they have the programs, but they don't put their money where their mouth is. I've seen far too much reluctance to accept people into the programs, even though they have the programs. So we have a long way to go.
I think that restorative justice, I always have a problem with big words. I believe that the concepts are used by the Missouri Department of Probation Parole for parolees. I believe they use some of the principles involved in their supervision of parolees. I mean, obviously, it's a fascinating. I love to read to see if there's any legislative efforts, because it is a very interesting area of how to try to protect rights of the victim, rights of the defendant, the court process, bringing in some of those ideas. But it's certainly fascinating. I hope that's not too much of a politician's answer to it, Shira.
You should run for office.
We have
I
some
can't
more
raise money.
questions. We have some big ones, so hopefully have a chance to get to all of them, but we'll do the best we can. The next question I have noted is, someone said, I understand that the US charges and their effects on life after imprisonment for various crimes are more punitive than other Western market economy countries, Europe, Canada, etc. What do you see as the reason for that?
Well, we are a punishment kind of place. The United States is, it's a punitive place, and until we are willing to do something different, it's always going to be like that. Our criminal justice system, from a defense standpoint and from the standpoint of an American citizen, I will say that it's there to punish people. And the problem is that the idea of sending someone to prison, we call our prisons departments of correction, or facilities for rehabilitation. But quite frankly, the way it looks is that those facilities are there for punishment. And that's just it's the way it is. And it's been this way since the inception. In Europe and in Canada, things were somewhat different. I speculated on this before, that because at one time they had the draconian systems that were led by kings and queens, they had to, when they reformed and became democracies, they had to go out of their way to not be the same as they were before. So it made their justice systems more about a compassionate approach.
One of the things that you'll see coming from some of those systems, honestly, as we talked last evening, the cost of doing the Department of Corrections and the cost of restorative justice and the recidivism rate for both are what people can look at for opportunities for growth in that direction. How much is it going to cost me to put you away, feed you, house you, clothe you for 30 years, plus after you get out, you're not going to be able to do anything but either reoffend or be not able to enter society in the way that could support yourself. So I'm going to support you through other programs, versus if we go through the restorative things. And that's a cost benefit analysis that, as people look at, they can begin to determine what is more effective for their community and what works better.
I've seen a lot of statistics about how many the corrections facilities they have in Illinois, in a state that's fairly broke. It's amazing that there always seems to be enough funding for correctional facilities. But then I heard that in the last reform, the pushback was from the Department of Corrections workers because they didn't want to lose their jobs. So we have a long way to go to figure that one out altogether with. It's just, if we say we want to put less people in prisons, I think that's a good thing, but we still have to be able to work on why they were there in the first place. We have to be able to work on why our society has created the ills that it has, because we have far too many people that are not getting the outreach early on. I think the church needs to spend more time with children to make sure that the children don't even go that route. And then it needs, I know it's hard to get in the home and help the parents so that the parents don't allow their children to go that route, but as far as the correctional facilities, it seems to be that they are an integral part of what we think society is. And that's why, we're a punishment society.
Next question for us, Christine, please.
Yes, there's a couple more. One is a big question and a good one. I agree more community support works politically and morally. When a person has the right resources, they can make great changes. A felony conviction is forever. Why? Why can't people really have a second chance at their lives? Why can't they serve on juries?
Yeah. And, the first thing we have to ask is, what is our attitude about that really? If we have a teenage daughter and she's going to spend the night at her friend's house, and we find out that her friend's dad was a convicted felon 20 years ago, what are we thinking? Let's be realistic about it. I mean, we have to search our souls on this. Or if you are a 23-year-old girl and you find out that the guy that you're getting ready to go out on a date with is a convicted felon, what is your heart actually saying? I mean, to be realistic, we do have to get the full Christian ethic in our heart and our souls. And yet we have to ask what probably is reality. I pray for that myself. I pray that I can get beyond all the prejudices and the other things that are infecting my head every day. And, sometimes when I'm with my clients and being judgmental on my own, I pray that I can that I can stop myself from being judgmental that way. So I think that has to be part of, our in church teachings. I think it has to be something that we share and spread. We tried it before in 67, 68, 69, to reach out to everybody. And I think the basic nature of the United States, the commercial took over, and then it kind of pushed everything to the side. But I'm saying right now, the one thing that would help restorative justice most is for it to be included in the church, not just in the courts. I think that's a very important part.
Plus, folks, I think, maybe we could get Father Steve back to talk about judge not, or by the measure you measure others, as far as the spiritual concept is concerned. But I think Shira would probably tell you, or what Shira's example, and it's so easy for me to say, but you have to get involved in the process, legislative process, to get the laws changed. So that's as far as expungements are concerned, because that's where it's going to come from. And so whether it's contacting your legislatures, certainly strengthen numbers, getting groups of churches together of all denominations. And as Shira said, take a look at both sides of it. Take a look at the rights of the victims, which are we all take very seriously, but it's always a balancing approach. But I think it has to be done in numbers by the churches, certainly not necessarily by the churches, you can do it. But I think it's a great force if you get a number of churches involved in taking a look at it. And that but I think the change obviously starts with prayer, but it has to come, but eventually it's going to come through the legislative process. Do you
You know,
agree
I
with
saw,
that, Sarah?
I'm sure she does. I just want to interrupt real quick. I saw a program in one of the churches where they brought the victims together with the offenders. The church did this as a way to promote the healing as well, and to address the concerns of the victim and address the needs and concerns of the person who was accused. I think that's a very Christian thing to do, and I was very proud of. I believe it was a Boston church that was doing that, but we need to have more of that here too.
Folks, if you want to be, you have to make up your mind of where you want to be. If you want to be tough on crime, then you're going to be punitive. If you want law and order, it's going to look more of what it looks like right now. It is not a completely legislative response. For example, prosecutors stopped charging low-grade marijuana long before there was a legislative response. Prosecutors don't charge certain stealings long before there was a legislative response. And we'll talk about that next week, but you have got to give them the room for that. That comes, the prosecutor makes the charge in the name of the people. You have to give them the room for that. So there are things that can happen that are not purely, which is why we're going around all of them. So there's the judicial discretion, and that's what we're talking about now. There is the prosecutorial discretion. There are the laws, and there how the community responds to certain things. And we'll talk about each one of them in depth. So just trying to make sure that we all take advantage of the 7 minutes we have remaining in this program. And
yes, and we have one more question. So hopefully we can fit in one more question. Is that all right? And then wrap up? Okay, great. So this person had a comment and a question, so I'll just read their comment. It seems that the issue of justice is very complex. On the one hand, the accused is innocent until proven guilty. If found guilty, the person has a supposed debt to the victim of restitution. Society also has an interest in being protected from further crimes that may be committed by the person, etc. That was their comment. And then the question is, in your opinion, what percentage of crimes are fairly directly related to the accused being poor?
In my opinion and in my experience, it's literally more than half. So I'd say even closer to 75%. And there's probably a couple of things that people are going to jump on me about saying. I think a lot of the very wealthy, they may be committing crimes, they're just not being prosecuted. So that's one side of it. But also theft oftentimes is about need. And even though you say, well, they didn't need that new dress, they could have, they needed food. But, you know, it's still about need. It's a person who is in a very bad financial situation has to come up with coping mechanisms, and they become habits that we think, oh, they didn't need that, but it's part of the coping mechanism. So stealing happens. Shooting happens because when you're in a neighborhood where you're disenfranchised and where lawlessness has taken over, and you're not getting the support of the law enforcement in your community for one reason or other, then you have to protect yourself. Then you have to take on a more violent posture. All kinds of bad things happen to the poor people that the reaction is crime. And so therefore, if we're going to do any real outreach, we as a church have to do outreach to help the poor, as Christ did when he walked the earth.
Any other questions, Christine?
That's all the questions I saw. Thank you.
Or were there anybody that needed to ask questions in the 5 minutes remaining? I want to try to get it in if we can. Oh, all righty. Looks like we will end on time. Thank you, everybody. First, thank you to our panelists, Philip Dennis, and a distinguished attorney in this area, and Judge John Newsham, also a distinguished judge in this area. Thank you for just enlightening us on everything and making sure that we have some actual steps to take as Christians. A lot of times we sort of pass along, what can we do? Thank you for just letting us know that there's a court watching program, that there are things that you can do with bond, that they can sponsor people on a recog bond to let the court know about things. There are things that can actually happen that people can do to affect the criminal justice system from this side.
I would, before you go,
Oh, go ahead, Phil.
Go ahead.
I'm also concerned because I have a lot of clients that have been going to the legal services for the Catholic Church, and they're saying that they're overbooked. I think we need to do something to help them to get more resources so that they don't have to turn people away.
And folks, I was just looking at the chat. I'm not as tech savvy, but I saw that Professor Rhonda Wilson is on here, who I talked about in the beginning about her, she and adults and students, and she's a professor at Florissant Valley Community College, are court watchers. If you want to watch the court, you can email me at john.newsham, it's john.newsham @courts.mo.gov. I'll send you the Zoom link. But I would just thank Shira. I'm voting for you, by the way. I already checked the box because you have some brilliant ideas and so well spoken. Thank you, Christine, for putting this on, and thank you folks for participating. I'm sorry for the earlier difficulties, but I guess I want to end by just emphasizing that obviously prayer first, but it has to be, you have to get involved. And I think getting involved in groups is most effective. And I think getting involved through all denominations or church groups is incredibly effective.
All right. Thank y'all, and thank everybody for participating. Have a happy
Big
Saturday.
thanks to Shira as well, who organized all of this.
Thank you. Thank you for
I'll be coming
panelists
back
and
next
Shira.
week. I'll be coming next week's participant because I'm anxious to hear next week's program. It is absolutely fascinating to have, I know among two people, to have Beverly Halber, the head public defender in St. Louis County, Wesley Bell. I'm really looking forward to it.
Yes.